In this podcast, we talk about the cases dealing with offers and invitations to treat. An offer to the public at large is usually made in the form of unilateral contracts, inviting members of the public to perform a particular condition, at which point they become entitled to a reward. Now, you've all read Carlyle and the Carbolic smoke ball. Here you see a patent for the smoke ball. And here you see the original ad used by the Carbolic smoke ball company. This is the ad that was at issue in the case. Now in Carlyle, the facts were that the defendants, who were manufacturers of a patented medicine product, put out an advertisement that promised £100 to the user of the smoke ball if the flu was contracted despite use of the item. The smoke ball is designed as a preventative for influenza or colds, and according to the ad, the user was required to inhale the smoke 3 times daily for 2 weeks. The ad also stated that £1,000 would be deposited in the bank to confirm the manufacturer's intention. Specifically, the ad said, there is a £100 reward will be paid by the smoke ball company to any person who contracts the increasing epidemic of influenza, colds, or any disease caused by taking colds after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball. £1,000 is deposited with the Alliance Bank, Regent Street, showing our sincerity in the matter. The plaintiff, Mrs. Carlyle, bought the ball and used as directed for 2 months, but she caught the flu and sued the Carbolic smoke ball company for £100. The defendant refused to pay. The issue here is, when is an advertisement an offer capable of acceptance? And the defendant argued that the vagueness of the document showed that no contract was intended. And if a contract is found, it would effectively be a contract made with the world. The court found that, in general, advertisements are mere invitations to treat. However, the advertisement here was an offer of a unilateral contract. Because if you look at the wording and the circumstances, a reasonable person would understand this advertisement as an offer for a unilateral contract. Now remember, first, there's the difference between the bilateral contracts and unilateral contracts. So a bilateral one is a promise exchanged for a promise. There is offer and acceptance occurring prior to the formation of the contract, and there is no performance necessary by either party prior to the formation of the contract. A unilateral contract, where there is an act exchanged for a promise, here the offer is accepted through performance by the offeree. It is unilateral because only the offeror's obligations remain. Carbolic's advertisement constituted an offer of a unilateral contract. It was accepted by Mrs. Carlyle, the offeree, through performance, that is, through the purchase and use of the item. Therefore, Carbolic was obligated to honor the terms of the contract and pay £100. Now here, there was a problem with the notification. The ordinary rule of law says that an acceptance of the offer ought to be notified to the person who makes the offer, to make the two minds come together. But sometimes notification is not necessary. We know this by looking at the offer itself. Read in light of common sense, an advertisement of this kind does not require notification of acceptance of the offer. So the ad doesn't say that if a person purchases the smoke ball, the person has to notify the Carbolic smoke ball company that that this person is purchasing the ball and intends to use it as directed. The ad lets a person believe that notification is not required here. In unilateral contract, performance of the condition is the notification. A person need not notify his acceptance of the offer before he performs the condition. The other point here is that the advertisement must be read in its plain meaning, as an ordinary person would understand it. Here you're seeing the reasonable person test. The purpose of the advertisement was to make people use the smoke ball. so that its use would be promoted. And that's exactly what Mrs. Carlisle did. The ordinary person would understand this as an offer to be acted upon. And third, even though the advertisement did not limit the public's use of the smoke ball or place any restrictions on it, that's the defendant's fault. The extravagance of the promise is no reason why the defendant should not be bound to it. So here you see the court protecting the public from extravagant promises. Just because you've made an extravagant promise does not mean that people are not entitled to rely on it. Now, the Carbolic Smoke Ball Company argued that if the court found this to be an offer, then effectively it would be making a contract with the world. And the court said, that's not so. The offer is being made to the world, and the contract is only being made with anyone who comes forward and performs the condition. Quote, it is not a contract made with all the world. There is the fallacy of the argument. It is an offer made to all the world. And why should not an offer be made to all the world, which is to ripen into a contract with anybody who comes forward and performs the condition? It is an offer to become liable to anyone who, before it is retracted, performs the condition. And although the offer is made to the world, the contract is made with that limited portion of the public that come forward and perform the condition on the faith of the advertisement. One last thing to keep in mind here is there were some background policy reasons that helped form the basis of the decision. This is at a time where there were twin evils of 1891. So there was the flu epidemic and medical quackery, and which leads to shady business practices, which is exactly what the court was trying to clamp down on. This takes us to the next case, Goldthorpe and Logan. The facts are pretty simple here. In this case, the defendant Logan ran an advertisement guaranteeing hair removal results. And specifically, it said, hairs removed safely and permanently by electrolysis, no marks, no scars, results guaranteed. The plaintiff, Mrs. Goldthorpe, made an appointment, and an employee of the defendant guaranteed the results in person prior to the treatment. Now, rather than provide the intended results, the hair growth continued. Mrs. Goldthorpe pursued two causes of action, tort and contract. The issue in this case was there a contract between the plaintiff and defendant? And the answer to that will depend on whether the advertisement can be construed as an offer. The ratio that comes out of it is, if an offer is made to the public, any member is free to lend oneself to the terms and conditions of it. Again, you see that in Carlisle. And the reasons for the judgment for the contractual claim were that the plain meaning of the advertisement indicated that it was an offer open for acceptance. The plaintiff accepted the offer by responding to the advertisement. The policy rationale here is to protect the weak and incredulous. Again, like in Carlisle and the Carbolic Smoke Ball Company, the court is not inclined to preclude reckless and rash statements from being classified as offers. If a party makes an extravagant promise, it cannot later escape a complaint. The strong cannot disregard any undertaking binding in law, however lightly given, and the weak, unfortunate person, however gullible, can be sure that the courts of this country will not permit anyone to escape responsibility arising from an enforceable promise. But some claims are recognizable by reasonable persons as puffery. So, was Mrs. Goldthorpe the reasonable person? And this is a problem that you're going to see again and again. Who is the reasonable person? This is a person who's appropriately informed, capable, fair-minded, knows the law. Now, was Mrs. Goldthorpe reasonable? We don't know, and it doesn't matter if she was reasonable. The judge determined that a reasonable person would have accepted the plain meaning of the advertisement as an offer, and that is enough to come to that conclusion. The next case is a recent application of the principles we see from the Carbolic Smoke Ball and from Goldthorpe. This case is called Leonard and Pepsico, and it's from New York, 1999. And some of you may remember this promotional campaign. Pepsi ran a promotional campaign where it invited its consumers to acquire Pepsi points by purchasing Pepsi products and exchange them for Pepsi stuff. Leonard received a catalog for use in redeeming Pepsi points, and there were television advertisements featuring merchandise available through the promotion, including a Harrier jet that was in the commercial. Leonard saw the commercials and contended that the commercial constituted a valid offer to acquire the jet for 7 million Pepsi points. Leonard obtained a catalog and noticed that the order form did not include the Harrier jet. The catalog stated that merchandise could only be offered via original order form. The form also indicated that additional points could be purchased for 10 cents each. Leonard raised $700,000 in order to purchase the 7 million points needed to acquire the jet. And he submitted a completed order form together with a check and wrote in, quote, 1 Harrier jet at the bottom of the form. Leonard indicated that the check was for the express purpose of purchasing the points needed to obtain a new Harrier jet as advertised in the commercial. Pepsi rejected the submission and returned the check, noting in its rejection that the jet was not in the catalog and thus could not be acquired through the promotion. Pepsi apologized for any misunderstanding and informed Leonard that the commercial was intended to be humorous and entertaining. Leonard sued when Pepsi refused a formal demand to honor its offer. The issue, similar to the last two cases we just discussed, was the commercial a formal offer. And again, we go back to the rule that advertisements are generally not offers. But is it possible for an advertisement to be construed as an offer? Well, we know that. It is possible. We know that there has to be some language of commitment or an invitation to take action without further communication. Since it isn't customary to do that, however, the presumption will go the other way, meaning we'll presume that the advertisement is a request to consider and examine and negotiate. In other words, when we see an advertisement, we will presume it is not an offer, unless that presumption is rebutted with plain and clear words. So what is the exception to that rule, that advertisements do not create any power of acceptance in potential offerees? Where the advertisement is clear, definite, and explicit, and leaves nothing open for negotiation, then we will find that it is an offer. The court in Pepsico compared this case with the advertisement for fur coats, which was a case called Lefkowitz. And the case of Lefkowitz was pretty explicit. There was an ad saying, if you come in on Saturday at 9 a.m. and you're one of the first 3 people, you get a fur coat for $1. The court determined that the Pepsico case is different than Lefkowitz. How? Well, the commercial in Pepsico was not definite. The commercial in Pepsico reserved some parts of the details to separate writing in the catalog. The commercial said nothing about the steps a potential offeree would have to undertake. There were no words of limitation. It was not precise enough. More detail is needed for a contract to be formed. Another issue is, well, is it an offer for a unilateral contract to be seen as making grand promises of public reward, such as the one made in the Carbolic smoke ball? Now remember, if a person makes extravagant promises, that is no reason for him to not be bound by them. So what is the difference between this case and the Carbolic smoke ball? Well, there the advertisement offered a reward. This is an offer to anyone who performs the conditions named in the advertisement. If you perform the condition, you accept the offer. In Carlisle, she complied with the terms of the offer. She contracted the flu and was therefore entitled to the reward. But here the commercial did not say that anyone who appeared at Pepsi headquarters with 7 million points on July 4th would receive a jet. Rather, it urged consumers to accumulate points and to refer to the catalog to determine how to redeem them. The commercial also sought a reciprocal promise. The reciprocal promise would be expressed through acceptance of and compliance with the terms of the order form. The order form never mentioned a jet. So remember, there is a difference between an offer and a typical advertisement. An advertisement is generally an offer to negotiate. How do you determine the difference? It is what an objective and reasonable person would interpret to be an offer. Clearly, the Harrier jet was a puff, and the commercial was absurd. It was a jest. It was clearly intended to be to get people's attention and not to make an offer.